Good morning, everybody. Are we ready?
Yes, we are, Chair. Ms. Tabashi will lead Mr. Mathebula.
Okay, thank you. Mr. Mathebula needs to take the oath or do the affirmation.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath in the prescribed form to be binding on your conscience?
Yes.
Please raise your right hand. Do you swear that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you.
Thank you. Ms. Tabashi.
Good morning, Chairman.
Good morning.
For the record, my name is Leah Tabashi, and I'm a member of the team of evidence leaders attached to the Commission. I will be leading this witness, who is Mr. Ndleleni Willie Mathebula. He is the acting Chief Procurement Officer at National Treasury. Chairman, with your leave, I just have a fairly brief opening statement before I actually lead this witness.
Before you do that, I don't know what it is, but I'm not hearing you as clearly as I should. I don't know whether raising your voice will cure that or what will happen.
Shall we try this? There's an echo when I bring the mic closer, Chairman.
That was better.
Was it actually better? I'll also try and speak up.
Yeah, okay, no, that's fine. But can everybody hear me well?
Yes.
Okay, all right, thank you. Let's try.
Thank you, Chairman. Mr. Mathebula has been at National Treasury for about 17 years. He will be assisting this commission as provided for in Rule 6.1, read with Rule 7.1, Chairman, by taking the Commission through the prevailing public procurement regime in South Africa. These two rules provide respectively that this Commission may receive any evidence that is, one, relevant to its mandate, which evidence, two, should be significant in advancing the work of the Commission. As will become apparent, the evidence to be tendered by this witness falls squarely within these parameters. It is contextual evidence that is intended to be one of the foundational building blocks that will assist the Commission understand, just by way of example, the institutional arrangements that impact the regulation of procurement in the different spheres of government. That's just by way of example, Chairman. The evidence of Mr. Mathebula falls outside the parameters of Rule 3.3. He does not implicate any persons in his statement. His testimony does not address the factual circumstances of any alleged malfeasance that may have taken place in the past. His evidence is technical and really intended to give context, nothing more. In the circumstances, there is no basis, in the view of the legal team, for any party to seek your leave, Chairman, to cross-examine Mr. Mathebula. Chairman, I beg leave to hand up a hard copy of his statement for your ease of reference. It will form part of the bundle of statements that will be handed up to you during the course of the Commission's work. And in that respect, I have marked it Exhibit B1.
Thank you.
Just to give a quick overview, Chairman, of the tasks of the Commission, this Commission has been tasked with inquiring into, with making findings, reporting on, and making recommendations to the President of the Republic of South Africa on the matters tabulated in terms of reference 1.1 to 1.9, guided by, among others, relevant legislation, policies, and guidelines pertinent to the matters under scrutiny. This is precisely where the evidence that Mr. Mathebula will be tendering will be positioned, with specific reference, of course, to the legal framework that bounds public procurement. Mr. Mathebula's evidence could also be of value in relation to informing the submissions that the team of evidence leaders may wish to make in relation to the possible recommendations that the chairman may want to make to the president. In due course, Chairman, evidence on the procurement of goods and services by organs of state will take up much of this commission's time. This is inevitable because one of the central allegations made in, amongst others, the state of capture report of the public protector, as reflected in terms of reference 1.4, 1.5, and 1.6, is that of the unlawful award of tenders and contracts by SOEs and public entities to private individuals, companies, business entities, and organizations. It is evident, therefore, that the testimony of Mr. Mathebula, which traverses this terrain from the perspective of what Section 217 of the Constitution sought to provide for, will clarify what the operational rules of engagement are that give effect to Section 217, I beg your pardon, of the Constitution. This testimony will also, I hope, throw light on whether the prevailing legal framework was or is open to manipulation by public functionaries, and if so, in what respects. In essence, Chairman, the testimony of Mr. Mathebula on the legal framework of public procurement is to assist this commission in discharging its mandate of establishing whether the allegations of state capture that have been made have merit, and if so, in determining what part of public procurement played a defining role in the form state capture may or may not have taken in this country. In closing, Chairman, might I indicate that as the Commission's work gains traction, National Treasury will in all probability be in attendance again to address any other matters that are of significance to the mandate of this Commission. Today, however, the focus of Mr. Mathebula will be very narrow. It is just to give context to the Commission on the procurement landscape, primarily with regard to public procurement, as well as state-owned entities, and not, as reported in one Sunday newspaper, to speak to the investigation reports that National Treasury has commissioned in the recent past. That's not the mandate for today, Chairman. Subject to any directives from you, Chairman, any matters concerning National Treasury that require further interrogation will emanate from the factual evidence that will be placed before this Commission in due course. As and when necessary, National Treasury officials can then be called to clarify relevant aspects pertaining to that factual evidence. It is possible, therefore, Chairman, that this will not be Mr. Mathebula's first and last appearance at this Commission. In like vein, it is hoped that the information that Mr. Mathebula will be imparting today is not the only evidence that National Treasury will be assisting this Commission with. Chairman, might I proceed to lead Mr. Mathebula?
Just so that one understands the significance of the evidence that Mr. Mathebula will give, is it correct to say it seeks to give the foundation on which any allegation that either state capture or corruption or fraud that falls within this commission's terms of reference entailed a departure from procurement processes. In other words, this evidence will say this is what should happen in relation to procurement, and if anything that happened in relation to state capture, corruption or fraud in relation to procurement within South Africa government, then it should have followed these processes. And if it departed, it means it was not in accordance with these processes.
Absolutely, Chairman. It's a yardstick. It
Yeah.
gives a framework
Yeah.
within which the evidence that will be led
Yeah.
by this commission can be compared to or tested against.
Yeah. Thank you.
Thank you,
You
Chairman.
may proceed.
Thank you, Chairman. Mr. Mathebula, is it correct that you are here to assist the Commission by explaining the public procurement framework that flows from the provisions of the Constitution?
Maybe before he responds, let me just confirm that he is happy to give his evidence in English.
Thank you, Chairperson. Yes, I am happy to do so.
Thank you very much.
Thank you, Chairman.
Okay.
You were going to respond to that question? That you are here to assist the Commission?
That is true, Advocate.
Thank you. And that the statement...
I'm sorry again. You will also have to try and raise your voice, Mr. Mathebula,
Okay.
so that we can hear. I don't know whether I'm the only one that has a problem. Maybe if I am the only one, then maybe there is something wrong with my ears. I hope that people right at the back can hear you well as well. So let's try and make sure we raise our voices sufficiently for everybody to hear. Thank you.
Thank you. And Mr. Mathebula, if you would please address the chairman. I know I'm asking the questions, but the responses go to the chairman.
Okay.
Thank you. The statement that I have handed up as Exhibit B1, which is dated the 15th of August and signed in Pretoria, is that your statement?
Thank you. Through you, Chair, yes, it is indeed my statement.
And is it a statement you wish to rely on in these proceedings?
It is correct, Chairperson, that is a statement that I will be relying on during the proceedings of today.
Please take the Commission through the salient points of your statement, starting with an introduction of yourself and your term of service within National Treasury.
Thank you, Chairperson. As indicated, of course, in my statement, my name is Willie Mathebula, and of course, Ndleleni is my African name. And I am currently the Acting Chief Procurement Officer at the National Treasury of the Republic of South Africa. This is a position that I have occupied since September 2017. Now, the Office of the Chief Procurement Officer is responsible for regulating procurement and modernizing the supply chain management system across all spheres of government. This office also plays an oversight role on procurement so as to improve efficiency and effectiveness in the system. Included in the mandate of the OCPO is the responsibility of promoting, supporting, and enforcing transparent and effective management of the supply chain management system. Now, since 2002, and prior to the establishment of the Office of the Chief Procurement Officer, I was employed as the Chief Director, Contract Management under the Specialist Functions Division within the National Treasury. In this position, I was responsible for facilitating the arrangement of transversal term contracts on behalf of government. These are contracts that are cross-cutting. If I may, through you, Chair, just explain a little bit what transversal contracts are. These contracts, of course, are contracts that are common across the whole of government. I may just make an example. If you take fuel, fuel is consumed by everybody in government, from Cape Town to Messina and vice versa. Now, this particular contract is transversal, and it actually doesn't make sense to allow every government department and government institutions to have their own individual contracts for the supply and delivery of fuel in the country. But what we do, we then consolidate all volumes and facilitate one contract centrally, of course, to derive benefits out of economies of scale, and also to apply government policy consistently. They are strategic in nature, and they also cross-cutting. That's what transversal contracts are all about, in a nutshell. There are many of these contracts, of course, in government. Now, in 2015, I assumed the position of Chief Director, SCM Policy and Legal within the Office of the Chief Procurement Officer at the National Treasury. In this position, I was responsible for the SCM policy development, including the setting of norms and standards for implementation thereof. In other words, setting the rules of the game, how the game should be played and within what rules. That's the position that I held prior to being appointed as an acting Chief Procurement Officer.
So, Mr. Mathebula, you therefore are saying to us that you have an intimate understanding of supply chain management processes, procedures, and prescripts.
Through you, Chair, thank you very much. Yes, I am. I understand the policies of government insofar as supply chain management is concerned. And of course, I discharge this responsibility with oversight over all spheres of government. That's the purpose of that particular position. Now, just as a way of...
If you could just pause for a second, Mr. Mathebula. You speak of all spheres of government. That would not include state entities, SOEs, etc. Just in that context, when you say this, over the spheres of government.
Currently, yes, all spheres. That would include state entities as well.
And you'll take the commission through when that position changed?
Exactly. I will take the commission as a way of background.
You can do so at the relevant time,
okay,
if you do not want to do it now.
All right.
Please proceed and just talk to the establishment of the office of the Chief Procurement Officer.
Thank you. The Office of the Chief Procurement Officer was established, of course, in 2013 by the then Minister of Finance. To ensure that there was transparency in the system and to deal, of course, with issues that related to the abuse of public procurement, corruption, fraud, and so on that was involved in them. That was part of the mandate, but the main mandate was to modernize the supply chain management system to make sure that it is effective and also efficient. That was the main purpose of the establishment of this office. And I'm sure it's now an open secret that there was, of course, a former chief procurement officer who is since not with the Treasury anymore, but I am acting in that position. So that was the role and the rationale behind the establishment of the Office of the Chief Procurement Officer. But this, of course, was to ensure that all spheres of government, I must say this, and government institutions would be regulated insofar as procurement is concerned through this particular office. And that's the role that this office playing currently, oversight over the public processes in government.
Mr. Mathebula, there are those who have the view that it's a standalone office, that is the Office of the Chief Procurement Officer. Is that correct? Where does it get its mandate from? How does it fit into National Treasury?
The OCPO, as we know it, the chairperson is one of the divisions within the National Treasury, and it reports to the Director General, who is an accounting officer at the National Treasury, and of course the Director General reports to the Executive Authority, who is the Minister of Finance at this point in time. So it is not a standalone department. It reports to the Director General.
Yes. Can we move on and deal with specifically the summary you have given under context, in particular the source of the mandate on procurement in government? What's the source of that mandate?
Yeah, I think we are one of the lucky chairperson countries in the world, because procurement is embedded in the constitution of this country. Section 217, which is a part of chapter 13 of the constitution that deals with financial matters. Hence, procurement is also an integral part of financial management. So that's where we draw our authority from, and that's where procurement comes from. The Constitution is an overarching kind of authority over procurement. And of course, out of the Constitution, we have the Public Finance Management Act. We also have the Municipal Finance Management Act. We also have the Procurement Policy Framework Act, the Preferential Procurement Policy Framework Act, from which we draw the authority in terms of procurement in this country.
Can I just take you back to your paragraph 2.1? And here you speak of government being the single largest procurer of goods and services. You deal with the policy decisions of government to leverage public procurement. Take the Commission through this thinking.
Thank you, Chair. It is correct that government is the biggest, single biggest procurer of goods and services in the country. That's a known fact. Now, given the size of public procurement, of course, government took a policy decision to leverage public procurement to support the achievement of broader socio-economic objectives. And the number of these objectives, you have black economic empowerment, which is part of this, your small business development, industrial development, etc. It's quite a number of objectives. However, the size of government procurement spend does give rise to the unintended but considerable potential for abuse of the system. The Constitution provides that when organs of state procure goods or services, they must comply with the principles of fairness, equity, transparency, competitiveness, and cost effectiveness. This means that organs of state must have reference to the above imperatives when procuring goods and services. As indicated earlier on, that Section 217 actually provides the basis for these imperatives, the 5 pillars. The aim, of course, should be to ensure that the attainment of value for money, that is the public money, should be spent in an effective and efficient manner. In addition, those who participate in competitive bidding processes must be treated fairly and without bias. That's the basis of Section 217(1). However, Chairperson, I must hasten to also indicate that there is Section 217(2) of the Constitution. And also Section 217(3), which are equally important and relevant in giving effect to the constitutional imperatives that mandate a public procurement function. The use as a base of open public tenders is generally regarded as the best practice. I mean, here in South Africa and all over the world, that's the basis. Dealing with public money, public funds. Therefore, when we're procuring goods and services, we should do so in an open, competitive process. In the case of South Africa, the use of open competitive bidding process is considered the best way to ensure compliance with the imperatives in Section 217(1) of the Constitution. And these underscore what is best practice.
Can I ask you to pause for a minute and apply your mind to this question? Are you able to give us an estimate of the size of, in money terms, of government's procurement spend? You may want to locate it in a particular sphere. You may want to go broader than that, just to give us a sense
Of how?
Annually.
Okay. Thank you, Chairperson. The estimated procurement spend in government is just in excess of 800 billion for goods and services. That's the figure that we're talking about, and on an annual basis.
Yes, thank you. Proceed. You were just going to finish off with paragraph 1.7.
Yes. I wanted to say, of course, as indicated earlier on, the PFMA together with the MFMA provide a legal basis upon which a comprehensive oversight function is created. The procurement system in South Africa is underpinned by the Constitution as indicated, the PPPFA, the PFMA, and the MFMA. Although there are other pieces of legislation that have an impact on procurement, it must be noted, however, that even these prescripts, this piece of legislation, must conform to Section 217 of the Constitution.
Yes. Can I then ask you, Mr. Mathebula, to speak to us about what you refer to as the procurement architecture that you oversee?
Okay. Thank you, Chairperson. The architecture of the procurement system in South Africa could be described as a center-led system. So in other words, the policy development is centralized, whereas the execution of the policy is decentralized. So policy centralized within the National Treasury, we determine the broader framework, but the execution of that framework takes place in a decentralized format. So government departments, government institutions, public entities develop their own individual supply chain and procurement policies, but within the broader framework which is centralized. And that is why every department has its own SCM policy, which takes its cue from the broader framework, and of course, to the PFMA, MFMA for local government, and the Constitution. So that's the architecture of this procurement system. Now, earlier on, Chair, I spoke about transversal contracts, and I think I must go back to this particular issue. To say the National Treasury currently does facilitate the arrangement of the transversal term contracts, as indicated earlier on, that you put together the volumes and therefore go out into the open market to derive economic benefits and out of economies of scale. So, but however, the day-to-day procurement of goods and services elsewhere, outside the National Treasury, is conducted through the SCM units. These are supply chain management units within individual organs of state, entities, public entities, and departments. Now, the distinct rules that govern individual procurement are formulated at an entity or department level as part of the supply chain management policies. And these are the responsibilities of the entities' accounting officers in the cases of government departments, and the accounting authorities in the case of public entities, because you're talking about boards. However, these accounting officers and authorities are also tasked with the responsibility to ensure compliance with the rules of the game as set out in the broader framework.
So when one looks at the history of procurement prior to the PFMA and the triple PFA, we had the State Tender Board Act. Where are the differences between what we had under that regime and this regime where you have devolved decision-making to entities lower down the trail from National Treasury? Just draw those distinctions.
Okay.
And explain why there was this change from the State Tender Board regime to the current PFMA, triple PFA regime.
Okay. Thank you, Chairperson. I think I must just spend some time here so that I explain this particular issue properly. Now, in 2001, there was a division within Treasury, just as a way of background, whose mandate was to replace the outdated rule-driven procurement and provisioning system under the now defunct State Tender Board, and replace it with a new procurement system in keeping with the Constitution, the triple PFA, the PFMA, and later on in 2003 with the MFMA. So one would always recall that the State Tender Board Act itself was enacted in 1968. This is years before the Constitution. And surely the State Tender Board Act was inconsistent with the Constitution. And this is one of the reasons why the shift from the State Tender Board framework to the public finance management system. That's one reason, the first reason. The second reason is that the State Tender Board Act in itself conflicted with the PFMA, because the PFMA was enacted in 1999 and the State Tender Board Act was still in operation at that particular time. So you had the PFMA that granted powers to accounting officers and accounting authorities to manage procurement. But at the same time, you had the State Tender Board, which was a body that would come every 2 weeks, and they sit at National Treasury and to adjudicate on tenders from Cape Town to Messina and vice versa. Now, the problem was that the service delivery was impacted because this was a body of men that would come and ladies would come and sit there and adjudicate. And if they don't adjudicate favorably with the recommendations of various state institutions, now the decisions of the board had to be communicated back to those departments. And you can imagine the delay. And this was done through, and by the time we received clarification, service delivery was impacted. So that's the reason why the State Tender Board had to be phased out. By the way, although the State Tender Board Act exists in the statute books, the board itself was dissolved finally by the Minister of Finance in 2008. And equally, the provincial tender boards, who were also existing at the time, were dismantled to make way for managers, accounting officers, accounting authorities to take the responsibility in terms of procurement decisions and manage their entities. That's basically the difference between what has happened. So accountability as we speak now vests with accounting officers and accounting authorities. That includes, of course, the procurement decisions, apart from other decisions that accounting officers and authorities are responsible for.
I suppose one can also assume that this decentralized approach that was adopted in the PFMA and later legislation really was also aligned to the change in provinces after 1994, because then you could actually devolve decision-making more readily to the 9 provinces as opposed to what the old South Africa might have had. So all these statutes were really trying to align a new way of thinking. This is what I would surmise. Is this correct?
Through you, Chair, it's correct, because there was a PFMA which, whose letter and spirit, of course, advocated for the devolvement of powers to accounting officers and to all the regions to make their own decisions. On the other hand, you had the State Tender Board, which was centralized. Decisions were taken at a central point. So then the decision was, of course, to align the procurement system with the PFMA and also the Constitution. So the State Tender Board had to give way to accounting officers to make those decisions in various regions of this country and at all spheres of government. I think the MFMA, of course, applies at local government sphere.
With the problems that have beset government in relation to the abuse of these powers that have been devolved, are there any elements within the old State Tender Board Act or system that might still be of some value to the South Africa of today? I ask you this just in the context of widening the debate around how to stem the abuse that all of us know has been taking place in different forms, really. I'm not even talking about state capture, just generally irregularities that occur.
Yeah. Chair, I think we are fortunate in the sense that the State Tender Board Act, I'm sure, has got certain elements that we can always draw from in crafting the new revised procurement system, as we are busy now with the review of the procurement system. There are certain useful elements that we can obviously draw from that system.
I note that under the heading legislative framework you detail a number of statutes. Maybe just give us the salient points around those and how these speak to one another. Alternatively, how you have oversight over what is done in terms of these pieces of legislation.
Thank you very much, Chairperson. An overview of the national regulatory landscape reveals at least 10 distinct pieces of legislation apart from the Constitution, dealing in direct and significant manner with the regulation of aspects of public procurement in general. These are the PPPFA, your Preferential Procurement Policy Framework Act, which is informed, of course, by Section 2173 of the Constitution. The Public Finance Management Act, as we all know with the PFMA, the Municipal Finance Management Act, the State Tender Board Act of 1968 that I've already alluded to, the Broad-Based Black Economic Empowerment Act of 2003, the Prevention and Combating of Corrupt Activities Act of 2004, the Construction Industry Development Board Act of 2000, the National Land Transport Act of 2009, the National Supplies Procurement Act of 1970, and of course, the State Information Agency Act. Now, all these pieces of legislation, of course, as indicated, must be consistent with the Constitution. And of course, the Constitution itself gives the National Treasury the authority to oversee procurement processes and to regulate procurement in the country. So these pieces of legislation are still subjected to the Constitution and, of course, by oversight, the National Treasury. Now, there are other procurement legislation which are specific to entities and sectors, industry or products. In addition, well, in greatly varying degrees of specificity, the procurement functions of particular organs of state and or in relation to the specific issues. These include the Financial Management of Parliament and Provincial Legislatures Act of 2009, the Road Traffic Management Corporation Act of 1999, the Armaments Corporation of South Africa Limited Act of 2003, that's AMSCO, the Administrative Adjudication of Road Traffic Offences Act of 1998, the Nursing Act, Public Audit Act, the Health Professions Act, the Housing Act, Disaster Management Act, and the Correctional Services Act. Now while these statutes regulate procurement across a range of organs of state, there are a significant number of statutes that deal with procurement by particular entities. And there are also statutes addressing procurement in relation to a particular sector, industry, or product, as indicated earlier on. Now, in most cases, these statutes prescribe procurement rules in addition to the rules that would apply to the procurement activities mentioned above, in terms of the more general legislation above. In some instances, however, the specific legislation operates to the exclusion of general rules, such as in the case of the Financial Management of Parliament and Provincial Legislatures Act, which governs public procurement by Parliament to the exclusion of the PFMA.
In fact, I know you've explained this to me, that in terms of the courts as well,
Yeah.
they too are excluded from the PFMA.
Yes.
Could you just take us through that?
Yeah. Chair, as indicated, courts and judicial officers are excluded from the Constitution.
I'm sorry, from?
From which part of, what part of the Constitution?
Section 217.
I'm sorry, can you just repeat? I missed something. You said the courts are and judicial officers are.
Does not apply to all organs of state as defined in Section 239 of the Constitution. Now, Section 239 of the Constitution.
Yes. You were also, in your statement, you also make the example of arms corps in paragraph 4.3.5.
4.3.
4.3.5.
Yes, just.
As being authorized to procure.
Yes.
Because it's a particular type of state entity.
Yes. Thank you very much, Chair, through you. Now, as indicated earlier on, that the Armaments Corporation of South Africa Act, provides a procurement system for the procurement of defense material, and it's applicable to defense. Now, this particular act authorizes the corporation, that is ARMSCO, to establish a system for tender and contract management in respect of defense material. And defense material is defined as any material, equipment, facilities, or services used principally for military purposes. The corporation is also authorized to procure commercial material, that is goods and services, other than defense material, for the Department of Defense and or any other organ of state in terms of a service level agreement between the corporation and such organ of state.
Now, Mr. Mathebula, just explain this to the chairman. What then is the control or the oversight role that National Treasury would have in those circumstances?
Yeah. As indicated earlier on, all these pieces of legislation are subject to the Constitution, Section 217, and also are subject to the PFMA, which grants the National Treasury an oversight role insofar as procurement is concerned. So that's the role that we're playing in as much as these pieces of legislation exist, but they exist within the Constitution, and the PFMA takes the precedence over some of this. And that is where the Treasury then is responsible to regulate, to make sure that all these pieces of legislation conform to the principles of fairness, equity, cost effectiveness, competitiveness, and transparency.
Could you then proceed to take us through your submissions in paragraph 4.4 of your statement?
Chairperson, there are other laws which are relevant for procurement. And they're very important when dealing with procurement. And these are PAIA, as we know it, PAJA, and also the Local Government Municipal Systems Act of 2000. So they're also very important because they form.
Mr. Mathebula, you have made reference to the Constitution, and in paragraph 4.5, you then take the stance that there are particular reasons why the Constitution really is framed, certainly Section 217 is framed in the manner that it is. Please take us through that thinking that you've reduced to writing in 4.5.1.
Okay. Chairperson, as indicated, The Constitution is the authority over procurement processes in the country, Section 217. There are a number of reasons why special and fairly detailed attention needs to be given to the Constitution in setting out the regulatory regime applicable to public procurement in South Africa. The first reason is the supremacy of the Constitution, which has the result that all other law is subject to the Constitution's prescripts and must be formulated and interpreted in a way that accords with the Constitution. The second reason is that the Constitution expressly creates the foundation for public procurement regulation in South Africa. A third reason is that while the Constitution provides the supreme basis for public procurement regulation, it does so only in broad, principled terms. To the extent that the public sector relies on public procurement to give effect to this constitutional mandate, the Constitution is thus of much broader relevance to public procurement generally than simply the provisions dealing specifically with public procurement regulation. The Constitution contains a number of provisions that can be viewed as creating the framework for public procurement regulation. Now, given the pervasive nature of public procurement involving, in essence, all state functions and all public institutions, it follows that the vast majority of provisions in the Constitution are relevant to public procurement in one way or another. For example, since the public procurement necessarily involves the spending of public funds, the whole of Chapter 13 of the Constitution is relevant. Likewise, since public procurement is inevitably tied up with public administration, the whole of Chapter 10 of the Constitution is of relevance to public procurement. Now, however, if one focuses on those constitutional sections that can be said to govern public procurement in a specific way, to the extent that they may be viewed as facilitating the regulatory regime applicable to public procurement, the following constitutional provisions are of direct relevance. Section 217 of the Constitution, Section 33, which sets out the basic requirements for constitutionally valid administrative action, and consequently, the grounds upon which administrative action may be reviewed by the courts of this country. And of course, Section 195, which sets out the constitutional values for public administration in South Africa.
If you would then, Mr. Mathebula, just speak to the issue of the scope of the application of Section 217, with emphasis on what you have referred to as entity, involvement, and transactions concluded. You find this on page 11 of your statement.
Okay. Thank you, Chairperson. The scope of application of Section 217 is determined by two factors. One, the entity involved, and two, the transaction concluded. Now, we've spoken about this earlier on around how does it cover organs of state that are defined in Section 239 of the Constitution, and also those that are not covered in terms of Section 239. Now, if I may, with your permission, Chair, just deal with Section 33. Yeah.
That's fine, Mr. Mathebula.
Is that okay?
Proceed.
Yeah. Thank you, Chair. The second constitutional provision that is of particular importance for public procurement regulation is Section 33 of the Constitution, which sets out the fundamental right to administrative justice. Section 33 requires all administrative action to be lawful, reasonable, and procedurally fair. Section 33(2) grants a person affected by administrative action of public functionaries the right to written reasons for such action. Maybe I should end here, Chairperson, and not further elaborate on what Section 33 provides. But of course, it is the basis for the Promotion of Administrative Justice Act, as we know it, PAJA. And Section 195, which is another section, the final constitution section of particular relevance for public procurement is this particular section, Section 195. This section sets out the basic values and principles governing public administration in South Africa. Now, given the centrality of public procurement in public administration, it follows that this section is also a foundational importance for public procurement. Moreover, among the values and principles listed in Section 195, there are a number of that are particularly apt in a procurement context. And I can go on and talk to them, but I mean, it is also clear in Section 195. I may just end here for now.
That's quite in order.
Yes.
You have mapped out the broad landscape of Section 217 of the Constitution, Section 33, Section 195 of the Constitution, and given the Commission a view of how these are integrated, how these are aligned. But of course, what flows from that is what you have here in your statement referred to as the specific regulatory instruments. And one of the most central ones is the PPPFA. Could you please, within the context of the work of this Commission, help the Commission understand why the PPPFA is such a central piece of legislation?
Thank you, Chairperson. The PPPFA, or the Preferential Procurement Policy Framework Act, is directly informed by Section 2173 of the Constitution. Section 2171, of course, lays those 5 basic principles. But Section 2172 provides that there is nothing prohibiting organs of state from developing a procurement policy that would take care of those who were historically disadvantaged by unfair discrimination in the allocation of government contracts. That's what 2172 says. And of course, 2173 talks about this national legislation. And this national legislation that we're talking about is this PPPFA. It is directly from the Constitution. Now, as with the PFMA and MFMA, the PPPFA mandates organs of state to formulate their own preferential procurement policies and to procure on behalf of those policies. However, the PPPFA significantly narrows down the scope for variation in individual preferential procurement policies by providing for a set framework within which individual policies must be formulated and procurement be done. Now, this framework essentially prescribes a preference point system for adjudication of contracts and tenders in terms of which certain categories of bidders are given preference, applies to bid adjudication in general, and is thus not restricted to only the preferential dimensions of public procurement. Now, the preferential point system in terms of this act prescribes in 90-10 preference system, where the 90 are points for price, and where the 10 are points for preference to advance the historically disadvantaged individuals. The 80-20, also the same. The 80-20 preference system, the 80 being the price, the points for price, and the 20 being points for the preferences that are allocated. And then when you take the 80 and the 20, the 8 and the 20 together, then you come out with a total number of points. And of course, the same with the 90-10 preference system. However, Chair, I must also hasten to say that whilst we take this particular preference system into consideration, there are also other special conditions that those who bid for government contracts must comply with. You've got functionality, the technical competency of the bidder to render a service in terms of a particular contract. So you take all these together, and then you come out with the highest scoring bidder who should be awarded a contract.
Mr. Mathebula, because this is one of the areas that some people identify as the soft underbelly of procurement, maybe it would be useful if you could take us through the criteria that would ordinarily be applied when setting up a bid evaluation committee and a bid adjudication committee, because these are the instruments that are used when this preference is allocated.
Yeah. Thank you, Chairperson. The SCM now, I think I must just explain this, because the supply chain management system is regulated, of course, through the PFMA and the MFMA. And these are the two pieces of legislation that prescribe how bid committees should be constituted. Whereas the PPPFA talks to how preferences should be allocated to advance historically disadvantaged persons. Now, the committees, in terms of the Treasury regulations, there are 3 types of committees. And that's what the SM system prescribes. Your first committee is what we call the bid specification committee. And this is a committee that sets the technical specification of what is needed. Whatever you want to procure must conform to certain technical qualities and characteristics. And this is the committee that sits and decides these are the needs from a technical point of view. And it's a committee that should be constituted by the user departments when they want to procure goods and services. Their role ends at the design of the technical specifications. Then there is another second committee, the bid evaluation committee. This is a committee that comes after a bid has been published and received. Their role is to evaluate that bid. And we prescribe in that at least these committees must be cross-functional in nature. In other words, you need to bring in different skills in that committee to draw at least expertise from various skills However, we also go on to say, the prescripts go on to say, in all these committees, there must be a supply chain stroke procurement person. Their role is to evaluate the bid in accordance with the criteria set in the bid specification committee and also as advertised, and produce a report, whether they recommend or they don't recommend. And then they send their report to another committee, which is a bid adjudication committee, whose role, of course, is to adjudicate on that particular bid depending on the delegation. If that bid adjudication committee is fully delegated to make a final decision, then they do so. However, if they don't have that full delegation, then they make a recommendation to the accounting officer or the accounting authority in the case of boards. And then it is a responsibility of the accounting officer and the accounting authority to make a final decision in terms of the recommendation of the bid evaluation committee. Again, in these committees, it is prescribed that they may draw as observers independent experts, but the role of experts is simply that. They provide advice, but they can't take part in the final decision-making of a particular contract, because that would then conflict with the accountability principle, which currently vests with accounting authorities and, of course, accounting officers. They sit there, they advise, and thank you, they leave. That is the observers and the experts in terms of these bid committees. So this is what is prescribed in terms of the rules of the game.
You see, you set out what is prescribed, as you put it, in the rules of the game. But we know just from the number of court applications that have taken up much of our court's time, that there's either a systemic problem or it's the way the committees are constituted. There is a problem that leads to irregularities. Are you able to help this committee, this commission understand where those issues arise in relation to these institutions or these tools that are supposed to have these Chinese walls, that are supposed to be impartial and apply set criteria, yet for whatever reason, do not do so?
The chairperson, I'm not so sure if I can answer, but I think I understand the question. There are a number of reasons. Some of the reasons, let me just state up front, some of the reasons could be intentional to abuse the system, but some of the reasons could be the interpretation of the application of the rules of the game. Of course, based on the capacity, because procurement as a system in itself does not have a professional kind of that professional. Still, you draw anybody can come and procure. You draw an HR person who may not have had a job in HR, and then you throw him into procurement. And these people do not understand the rules. But if you look at what has been happening in the past years, I'm sure one could always ascribe at least more than 50% of these infractions to intentions to abuse the system.
Chairman, I notice it's just about 11:15. Might this be a convenient time to take the tea adjournment?
Yes, thank you. We'll take the tea adjournment until 11:30.